Good morning, class. So today we'll be discussing about president powers and functions of President of India. So as you all know, ours is a parliamentary democracy, and parliamentary democracy, president is a nominal head or the main executive member. So every order that has to be sent or to be made as an act should have president's assent. So we'll be discussing about like what are the powers, functions of president, and what authority does president hold for her position in that of India. So president is head of the state, and us as a republic head, as you all know. And office of president is highest authority, like not just first citizen to be called, but it is also the first constitutional authority in that of nation. And president is also a nominal head who is indirectly elected. And the president, the main purpose and duty of president is to protect the constitution and also to analyze and to uphold the integrity of these three other wings, which are legislative, executive, and the judiciary. So, president, all in all, acts as an authority who would look into such issues. So now let us understand the position, the qualifications that one must need to become the president of India. So, president, as we know, it is president is the head of the state and indirectly elected for a period of 5 years. So now, what is this? They are what is this indirect elections? See, the president has to be a person who should be elected to the house. So, in spite of getting elected to the house, the office shall be for a period of 5 years. And as we have read in the Parliament's lecture yesterday or in the previous class, that president can prorogue and summon any session of the house. He summons the first session of the house and he puts to vote the motion of thanks, which is held after the first session, like the immediate addressing session. And so the indirect elections happens to it by the members who are elected to the parliament. So and the state representation will also be there. So and president of India can only be removed through impeachment process. So let's suppose as a parliamentary system, so here the president is elected indirectly by the elected representatives who the public elect. But if we compare it with office of president of USA, there, it as it is a presidential system, the president is also a real executive. So the president holds the power, and president will have the authority to look over the legislative and the executive wings. So there, the president is elected through direct elections. So through they'll conduct through debates, and after that, the elections were put the candidates were put to vote. Then the highest candidate, whoever so gets the vote, will be selected as the president. So here in India, the you and me as being like as we are a normal citizens, we cannot directly participate in the elections of the president, but rather we will elect the MPs and MLAs through direct elections, and those MPs and MLAs through direct elections, they will elect the president. So, in a way, the president of India is elected indirectly. So, the public participation is through a veil, is through the second shift. So, that is why we call it indirect elections. And the president is also first citizen of India. So, the first question or an MCQ question, if you come across, which says who is the first citizen of India, then it is a president of India. And the president is also the constitutional head. So she is first in everything. So the qualifications will range from Article 58 to 59. This is also again important. So the qualifications, certain qualifications are needed for any person to be elected as a president of India. So, which is first thing has to be they have to be a citizen of India, and they should be above 35 years of age, 35 and plus years of age, and registered as a voter in any parliamentary constituency. There is no fixed constituency that they have to be as so such, as it is president for the India, not for the state. So they have to be registered voter in any parliamentary constituency and should be eligible to be a member of Lok Sabha. Matlab, here you have to understand the convention. The president has to be a member of Lok Sabha. Now, who are the members of Lok Sabha? Members of the Lok Sabha are the persons who are directly elected by the people. So, these direct elections of a person getting elected to the house, then through the people who are directly elected by the people, they choose one person that has to be a president. So I hope you are understanding. That is why they must be uh, eligible to become the member of Lok Sabha. And president should not hold any office of profit under the union. And method is through indirect election through electoral college. So this also like voting system, ballot paper system will go on, and by proportional representation. So proportional representation is nothing but the whoever gets the highest number of votes, they would be chosen as the candidate. In a way, what happens is the minorities, linguistic, religious, or various categories of minorities would also be represented in that proportional representation on the first past post system. This is by single transferable vote. So this has a weightage. So this weightage of calculation will understand now. So now principles of uniformity. So which maintains parity between center and the states. So through this single transferable vote, they are trying to bridge this uh, divide, which happens to be usually the center will have the union will have the higher authority or higher stakes in election of president. To avoid that thing, we have come up with single transferable vote and through a voting percentage. So now what happens? The value of votes of elected, it also consists of value of votes of elected members of state assemblies. Then value of vote, how do you define value of vote? It is quotient obtained and divided by 1000 to obtain the value of vote of each member. So that we'll read it in now. Now what happens is, I think it is here. Yes, we'll go through the slides once we finish the certain qualifications. So now the value of vote of a member divided total number of votes given to all the elected heads of the state assemblies by total number of elected members of both the houses. So this is the voting percentage that we calculate the president elections, and it is a single transferable vote, and people with absolute majority will only be elected, will only be selected as the candidate to become the office of president. And the term is 5 years. This is mentioned in Article 56. Then oath is administered by Chief Justice of India and eligible for re-election. Okay, so now the term of office is 5 years. Why it is fixed? It is fixed in terms with Lok Sabha, and president has authority. They can dissolve the Lok Sabha at any moment if they deems that the majority has lost confidence through no confidence. And the oath of president to the office of president is administered by Chief Justice of India. This is also an important MCQ. So Chief Justice of India administers oath to the president office, whoever the candidate is elected through absolute majority. Then eligible for re-election. So President of India is eligible for re-election for uncertain terms, but whereas the President of America is eligible for re-election for only 2 terms. So that is the difference. So in USA point of view, the president, suppose elected for 5 year term now, they and elected for 5 years term in the next elections, then the third elections they cannot participate. But in India, usually the re-election there is no boundaries, or there is no limit on president or candidate to be elected as a president. So here, as so that mostly the people, those who have a lot of experience in the political field and have come through long period, only them will be elected to be president, right? So the term of unlimited number, getting unlimited times to be as a president of India would also cut off, because mostly the age limit would be cut off naturally. So that is why we did not go for this convention of only 2 terms, only 3 terms like that. Now let us calculate this value of president. Let's suppose, how do I calculate a vote of MLA? So the vote of MLA is last census population of the state divided by total number of members of the assembly. So census population, the whatever the census population that we had at the latest moment, that total number of population of the state of an MLA belonging to that state divided by total number of elected members of the assembly. So the the assembly's house numbers that will be calculated. Let's suppose population of the state is so and so and elected members is this much. Then how do I calculate the vote of each member is, so the population of the state divided plus elected members of the assembly divided by 100. So that would gather fetch me 100. So value of vote of an MLA, here they will be calculating like this. Then value of vote of MP. MP is value of vote of MP is total values of all assembly members and total number of elected members of both houses of the parliament. This is like division. Value of vote of MP is total value of all assembly members divided by total number of elected members of both houses of the parliament. Example, elected members of both houses of parliament is 750 and total value of votes is 50,000, and value of vote of MP is 50K by 750, which is 663. Therefore, the value of vote of MP, one MP is 67. So these numbers are like, this is how the single transferable vote and the proportional direct proportional representation would go on like this. So that is how, in a way, it do not give power of electing president through only few parts of India, but rather it is distributed all over the India. Excuse me, like this percentage that we come up with. Now, next one, President of India. We have to read the article, certain provisions and all. So the 56 is for procedure for impeaching of president, and 60 is oath of president by CJI, Chief Justice of India. Then Article 61 deals with removal on grounds of violation of constitution. And impeachment has to be initiated in either house of the parliament and must not be passed less than two-thirds of total membership of the house, and 14 day prior notice, etc. All those things goes. Now, Article 56 deals with procedure for impeachment of president. The president of the India can also be removed through a process of impeachment, and the, as we read, the who administer the oath, Chief Justice, and they can also be, Article 61, they can also be removed on violation of constitution. So this, how do you prove that on the grounds of violation of constitution is if the president has been a threat and they have been passing on the information to the enemy states and by betraying their own state as in the India. So through on those grounds, you can remove the president, and impeachment has to be initiated either in either of the house of the parliament. Here, Lok Sabha and Rajya Sabha has equal authority. In any of the house, the impeachment process can be initiated, but this should not be initiated by not less than two-thirds of the total membership of the house. So, the total membership of the house and two-thirds of the members shall be present in order to present and vote in order to draw this impeachment uh, process. Then let us read the most important thing. What are the powers of the function president? So president has all the ordinary powers include executive, legislative, financial, and judicial, and also the abnormal powers include emergency powers, diplomatic powers, all those things. So first, let us understand the executive powers of President of India. So the powers as such, he's an executive authority, so executive head. So what the President of India should do is they have to uh, be working on aid and advice of Prime Minister along with the Council of Ministers. And also, as per Article 75, the Prime Minister's duty is to communicate to the President on all the decisions of whatsoever they have been taking on behalf of Council of Ministers. So this is a convention which has created for the smooth functioning, that there should not be any crux, any issues between President and the Prime Minister or the President and the lawmaking bodies, so that the bills would be assented easily, and the constitutional failure structure would not lead to a failure. Then Article 77 is all executive powers of the government shall be exercised in the name of president. Now, what does this statement say is, let's suppose there has been a debate going on certain bill that has been put in the house. Now, after going through all the debates, discussion, and putting to vote, it has been passed by Lok Sabha. Now, the similar bill has been sent to Rajya Sabha, and there also the procedure, debate, discussion, etc. They will also pass the bill, and now what happens is this bill will be sent to the president. So this will be sent to the president. It can only become an act or an order or any as such document proof only if president signs on it. So that is why so this becomes in a way indirectly, or whatever the executive orders, executive powers, or whatever the executive authority that shall be go on, it will be addressed in the name of office of president. Now president is also supreme commander of the forces. Now President is the supreme commander of the forces, and he is the powerful authority. He holds the military, navy, and the air force and everything. And a president only appoints army chief, navy chief, and air force chief. And he has power to declare war and promote peace. So it is a president of India who issues an order to declare any war or an external aggression, or draw a war on another nation, and he is the only authority who can declare peace. So the president also appoints prime minister, council of ministers, attorney general, chief justice of Supreme Court, High Court, UPSC chairman, election commissioners, and the governors of the state. So these are all the authorities who president appoints at. So you can see that addresses them, he gives this assent to appoint them. Now next one is Article 79. So Article 79 talks about like union. So this was a thing like president, does she belong to the union or does she exist outside of the union? So now this Article 79 clears that president is also part and parcel of this union. And president can summon both the houses for joint sessions, which is presided by the speaker of the house. Okay, so and president have power to dissolve Lok Sabha. Yesterday, previous lecture, we have discussed in the parliamentary chapter that president can dissolve the house if he thinks that the what do we say, the confidence is lost in the house, and he is a president, she is the first one to address first session of the house. Let's suppose all the members are elected after the general elections, and they have been called to the house, and all the students as such, or all the MPs have come to the house, and it is addressed by president of India. Okay, so President of India addresses the first session of the House, and it is put to motion of thanks will be put to vote. And President also nominates 12 members to Rajya Sabha. Rajya Sabha is a permanent house, is a fixed house. So out of the indirectly elected MPs, the other 12 members would also be nominated to the Rajya Sabha by the president only. Then money bills are introduced in parliament only after prior consultation of president. That is why money bills, uh, while passing on the money bills, they cannot be rejected, they cannot be pocket vetoed, or they cannot, the president cannot say that I won't sign, because she is the one who introduces them in the parliament. So that is why the money bills are very crucial. So in a way, if you are rejecting a money bill, you are rejecting, you are questioning the authority of the president. So in a way, that is why the money bills rules and regulations are all different. And bills regarding formation of some other bills which are introduced uh, after prior consultation of the president is bills regarding formation of new states, altering boundaries of the state. This is like basically the delimitation commission. Delimitation commission is presided by the president of India. So she has the authority to decide the constituencies based on their population. Now, the new delimitation committee has yet to give or has yet to be formed because the previous one will be expiring, and the names of existing states shall be approved on prior recommendation of the president only. So that is why if you keep saying name change of the states or anything as such, so the president assent has to be done. So president should approve it before. And formation of new states also. Which one was the latest state? So 2014, the Telangana state, which is the latest one. This was also basically the president has priorly recommended or given permission, then only the bill was formed. Then, in order for bill to become an act, president can assent the that bill. That is what I've been explaining for so long. So the president can withhold any bill except for the money bill because with a prior recommendation only, that bill was introduced. So if the president have had doubts earlier, he would have rejected it earlier itself. So after checking thoroughly only, it was recommended to be, it was given permission to be introduced in the House. So in a way, the president, if suppose a bill is sent to the president, then president now cannot reject this money bills saying that she won't sign, but the other bills, they could be pocket vetoed. The president can deny signing them. President can reject signing them. President can send that bill back to the House for prior recommendation. So after that, even the discussion has been done. If the bill is sent to the president, then she has to assent. She cannot reject that after prior recommendation thoroughly gone through bill. Then money bills also she cannot pocket veto them. So these are all necessary conditions, the conventions that parliamentary powers or the presidency powers that has been devolved on. Now, but once it is passed, yes, president shall have to assent it. Then ordinance making power. The ordinance making power is one of the crucial power of the president. She can make executive orders or ordinances when the session, when the parliamentary sessions are not in, parliament is not in conducting the sessions. It was in that period where they have already conducted, and the ordinances are issued for the times of emergency. So the president can promulgate ordinances in public interest when parliament is not in session. And let's suppose the parliament have come back into power. Power as in like their session time has come into picture, and the promulgated ordinance, if the parliament passes it on, passes means executive orders passed, put to vote and discussed and voted on it in within 6 weeks, then that ordinance will become a law. So otherwise, this ordinance will deem to exist. So this is the other ordinance making power of the president that you have to remember. I hope you understood. I'm thinking you understood. Like, let's suppose this parliament was not in session, and due to some emergency issues, the president had issued the some executive addressing the public emergency. Now parliament have have come. Ha Suppose the parliament had this monsoon session. Now what happens is these ordinances which were circulated, were promulgated by the president when it was not in session. If the parliament passes this, puts this ordinance for discussion, then debate, then gives vote, then that ordinance can become an order. Then ordinance can become an act. Let's suppose that the parliament did not consider that ordinance because it was that not that important, or it was only done for that certain period of time, then that ordinance can deem to exist. So that will cease to exist because now the power making authority have come into picture. The president is empowered to remove inconsistencies between laws made by the parliament and state, and in subject matters related to concurrent list under Article 254. So the main objective or the main power of the president is to maintain the the order of the parliament, or maintain the order between three bodies. So the parliament, so the president is also has authority President also has authority to empower such, let's suppose there has been an discrepancies in law, uh, which is under union list and the state list, and this list and the state list has been having discrepancies, then president can settle those issues. Now she also appoints the supreme justices of Supreme Court and the High Court, of course, through the recommendation of three judge bench only. So once the three judge bench uh, picks up their viable candidate, then the president can appoint them and administers their oath to uh, Supreme Courts and the High Courts. And president has power, only the president has power to pardon any death sentence. Otherwise, president has also power to grant pardon, reprieve, suspension, remission, commute any punishment, including a death sentence. So president has right to seek advice of Supreme Court on issues of constitutional, legal, and diplomatic matters. Let's suppose there has been some urgency and emergencies that has to be addressed on. Now the parliament in terms of that such discrepancies, he, sorry, now the president in terms of such discrepancies can approach Supreme Court and seek their advice on such constitutional and legal matters. Then emergency powers of president. Now what happens is president can declare three types of emergencies: national emergency, the president rule, and financial emergency. Now national emergency is taken under Article 352. War, aggression, and armed rebellion are termed as national emergencies. This is under Article 352. Then Article 356 is emergency due to constitutional breakdown. What is this emergency? Let's suppose uh, the proper functioning of the constitutional machinery that has not been happening in particular state, and governor of that state will write a letter to the president saying that the state is deemed unfit to be properly functioning on the constitutional lines, so please impose an emergency. So this emergency is nothing but president rule. So this president rule is done under Article 356. And another emergency as such is Article 360, which is financial emergency. Now, what is national emergency can be proclaimed? Article 352. National emergency can be proclaimed if India's security is at risk. So Parliament have to pass this proclamation with two-third members present and voting. So initially, this has come under imposition of national emergency during Mrs. Gandhi's time, because President has given the issues or ordered of Article 352 that there has been national emergency, external war aggression. But after that, certain conventions has been made, so this president can approve that national emergency order only if it is passed by the parliament with two-third members present and voting. So they have added this convention or clause and to be approved within 1 month only. And emergency can be continued till 6 months. So so this whatever they approve proclamation of national emergency, it can be in one stretch. It can be extended up to 6 months, and after that it has to again pass through this proclamation of two-third members present and voting. Then emergency can also be extended up to 6 months, and the parliament can revoke emergency. This resolution has to be passed by 1/10 members of the Lok Sabha present and voting through simple voting only. For them, in order to proclaim this national emergency, it has to be passed by special majority with two-third members present and voting. But once if they have to revoke the national emergency, then it can be passed in Lok Sabha only with 1/10 members present and voting with simple majority. So with simple majority, it can be revoked. Then Article 356, which have to talk about SR Bommai case 1989. Now what happened here is President can declare emergency only if it is approved by the both houses. So this has come into picture where the President has authority, although President is highest authority in proclaiming the or addressing the national emergency, but her only authority comes into picture once it is approved by both the houses of the parliament. And governor of that house, oh, this is under Article 356, President rule. But the governor of that house, of that assembly, of that state, sorry, of that state, dismissed the dismissed as in he declared that there is no confidence in the leader of the government when the 19 letters which were been given by the council of ministers saying that we lost confidence in our leader, so please dissolve this house. But then some things happened outside of the meeting or anything, so again this council of ministers or these ministers have again put a letter to governor saying that no, that was just all right. We have decided the matter. The We have this now confidence in our previous leader itself. So please do not dissolve this house, reinstate this house. But governor did not do that. So governor did not do that, and the things have happened, and that is why the president can declare only if it is approved by the houses. Now, 44th Constitutional Amendment, this has what happened is 44th Constitutional Amendment Act. This is not Citizenship Amendment Act. This is Constitutional Amendment Act, 44th Constitutional Amendment Act. This has extended duration of president rule for 6 months at one go. So it cannot be extended more than an year, and total period shall be of 3 years. Now, this Constitutional Amendment Act 44 has brought up it has addressed many issues that was previously not addressed in the Constitution. Now, what happened in this 44 Constitutional Amendment Act is they have come up with a certain rules and regulation that has to be imposed or applied on President rule. So, the President rule can be approved for 6 months, and at a stretch it has to be 6 months, and this cannot be extended more than that of 1 year. So after that, more than one of that year, the constitutional machinery at the state has to be addressed. If so possible, elections have to be conducted also. So the total period shall be of 3 years. So overall, the president rule can be applied to be period of that 3 years is the maximum limit, but it cannot be extended more than that of a year. But you can at one go it can extend it 6 months, like 6 months, 6 months, 6 months, like that. You have to keep doing it. Then Article 360 is like financial emergency, which this can also be done only. These all the emergencies can be done by the president only on aid and advice of the prime minister along with council of ministers only. So this is a discretionary power of a president where it says that he is the reinstated authority, although he's a this is what tells about she being the nominal head. So we can see the nominal powers of the president through this uh, clause. Now, emergency powers and the critical remarks. So, H.V. Kamath the H.V. Kamath, he has been saying that this emergency powers of President of India or to proclaim emergency have been a sorrow and shame, because many a times this presidential rules or emergency powers have been misused or misabused. So, in a way, the president has been acting as a dictator in those terms. So, if we look at the details, so the president rule has been imposed on various states, uh, or this has been misused or abused. Now, what happens in most of the states? So, the top list would be number of times the president rule has been imposed is for number of times is Kerala, and next one is Uttar Pradesh, which is also 9 number of times. Then next state that is been imposed is 8 times, which is Punjab, and next comes in picture is 7 times, which is Manipur and Bihar. The next is 6 time, which is in Puducherry, And the remaining all the states, which is around like 5, 3, 2, they are like Goa, Gujarat, Andhra Pradesh, Assam, Bihar, sorry, Assam, Tripura, Tamil Nadu, Sikkim, Rajasthan, then Odisha, Meghalaya, Mizoram, Manipur, Maharashtra. So all this West Bengal. So all these states they have been imposed like 5 to 1 times, and the only state, few states that has been imposed one time is Meghalaya, then Arunachal Pradesh. But the highest number of times it has been imposed in Kerala and Uttar Pradesh, and next in line, which is 8 number, 1 number less is Punjab. So this basically Kerala, Uttar Pradesh and Punjab. Many number of times the president rule has been imposed. So now what this has led? This has led to president be acting like a dictator because the democratic institutions have been shut down, and emergency provisions will kill the federal character of India. So India, we know it's a federal, quasi-federal state. So here the both the powers, union, federal, unitary in structure and federal in power. So this emergency provisions will kill federal character of India, which is why, because now once the president rule has been imposed, the the central would be controlling the state authority, and the state's functioning would be abruptly disrupted. So in a way the whole of that state is controlled by the union. So in a, this is what led to federal character would be dissolving, so which is one of the basic structure or basic feature of the Indian constitution, and it is anti-democratic and may lead to totalitarianism. Now if you're gonna throw off the constitutionally and democratically elected institutions, you are in a way objecting the people's right to vote, and people's authority who have been elected by the people through direct elections and through democratic procedures, and you have been canceling that out, and implementing the president rule would have the control of like a one man show, control of the center on the state's authority, revenue, finances, whatever the laws that has to be made inside that of state. So this is in a way leading to uh, totalitarianism, or taking control of the power and the disruption of the constitution. So it is a symbol of authoritarian feature of Indian constitution. So if suppose there is a question that comes, what are the features that denotes the authoritarian feature that of Indian constitution are emergency powers. And during an emergency, most of the fundamental rights, including Article 32, are suspended. That is why this will turn out to be a dictatorship or one-man show or an autocratic rule. Even right to go to court under right against constitutional remedies is also suspended. So except for Article 20 and 21, the remaining all other fundamental rights will be suspended if there is a national emergency, or if there is a president rule in that of India and the states. So this is why the national emergency. This is why the emergency powers are deemed to be undemocratic in nature, because they violate the very persona of the citizens' rights, which are fundamental rights. This fundamental rights chapter, fundamental rights lecture, we have read this all rules and regulations and the limitations and certain clauses and the provisions. So please go through those lectures also, which are available. So this is a during an emergency, most of the fundamental rights, including Article 32, are suspended. That is why the president could be acting like a dictator. Then declaration of financial emergency might harm rather than help the financial position of the constitution. This has been said by the constitutional experts. So the constitutional experts have come up with the data, because the data which I've told now, like 8 to 9 times in Kerala, Punjab, and Uttar Pradesh. So this has led to the the autocratic or authoritarian position of the president and the your federal feature has been disrupted. So, in terms of declaring any financial emergency, the will disrupt the state's authority over the make lawmaking power, and it will be under the control of center. This may, in fact, will oppositely harm the financial position of the state rather than helping it to control the financial outbreak or the depressive phase that has been going on. So it has been said by the constitutional experts. Now, what happens is in a financial emergency, the president may reduce the salaries and allowances of the employees and including the judges, high courts. So people will be cut short of their salaries. Then the president can direct the states to reserve money bills passed by the state legislatures for the president's consideration. Then the union government is empowered to extend this executive authority to fix the financial matters, and central government gets total powers on financial matters. So states authority will be cut off. That is what the money bills which have been debated and put to vote have, that can also be stalled by the president. And the financial emergency, gladly, it has not been declared uh, till now in that of India. So this Article 360 is also very important, and this could continue for 6 months if it is approved, and it has to be approved by both the houses of the parliament within 2 months. So if a bill is passed in Lok Sabha and it has been sent to Rajya Sabha, then there also the voting procedures, the debate, discussion has to go on. So this time, and it has to be get assented by the president. This all debate, etc., voting have to go on within 2 months from the introduction of this bill in the house. Otherwise, it lapses. So that is the certain criteria for it to be passed on or for it to become an act. So so this is what the financial emergency of it. And if there's a question, MCQ question, how many times the financial emergency have been imposed in India, which is 0 times. But the presidential rule, I've said Article 356, this has been imposed many number of times where the constitutional structure of the states have been disrupted. Now let us understand. This is always a debate and discussion. Uh, who is the president of India? Like, is it the nominal head, the constitutional authority, or a real or is executive head? Because all the executive functions have been carried on by under the assent or approval of President of India only. So now, why do we call President office as a nominal head? Why can't it be called as a real head as that of in USA? So this is through this debates we can understand what. So first one, President of India. She's a constitutional head of Indian Republic, and she's the highest authority in India. And she's also nominal head of the nation. Now what happens through Article 53? The Constitution vests innumerable power, all the executive powers under the President of India. And President is obliged to act according to the advice of union ministers needed by the President. Although Article 53 gives immenseable power to the President of India, to the Office of President of India, but still the President has to act on the aid and advice of Council of Ministers. This aid and advice of Council of Ministers has come into picture during, as I've told you, during the emergency where the President has, or during some of the other times where Prime Minister and the President have this discrepancies going on between them. The things were not smoothly functioning, and president was vetoing most of the other bills that has been passed by the houses. So this has created a loss. This has created a constitutional disruption, and it was a very hectic and time taking model. So the president, it is said that through convention, although Article 53 vests immensible amount of power in the hands of president. President still should act on the aid and advice of prime ministers, aid and advice of council of ministers headed by the prime minister. Now, the one question that you have to understand is, can president enjoy independent powers? Has the constitution entrusted an active position to the president? So what is this active position means? She voluntarily, like we might have read it in judicial activism chapter, where judiciary actively participates in lawmaking, in reading the laws or reading acts that have been passed. So here also, his office of president is just a rubber stamp, or they have authority to actively participate, actively play a role in making such policies. Now, the main important function of president of India is under Article 360. The main duty of president is to preserve, protect, and defend the constitution. So this, in a way, has given the authority of the president that if anything goes against the constitutional structure or the constitutional provisions, the president has all the authority that is vested in of constitution through Article 60. They have to preserve and protect the constitution of India, and they can also defend the constitution of India no matter what. But this also comes with a limitation that, as per Article 74, the president is obliged to act in accordance with the advice of Union of Council of Ministers headed by the Prime Minister. So this Article 74 and Article 60, you should not read it separately. So always the Article 53, Article 60, and whatsoever article that deals with the executive powers of the president should always be read with Article 74 of the Constitution. These should not be read in isolation. So, what happens is, although the president has all the powers, executive powers, and she has this power to defend the Constitution, protect the Constitution, she still have to do or take these decisions only on the aid and advice of Council of Ministers headed by the Prime Minister. So you should never read the executive powers of the president in isolation. That has to be supplied with this Article 74. Now let's suppose President lost confidence in House of the People. Now President is supposed to act independently by discretion in only such matters. President cannot act independently to discretion in executive matters. So, okay, understood. Then she is not merely a nominal head, might not follow the advice of Council of Ministers. So, the president is neither a real nominal head and nor a real head, but a constitutional head. In such matters, you can debate it. There, in executive matters, president is a nominal head. But when it comes to a house losing its confidence, then president is a constitutional head. So the powers and the position keeps tilting based upon the issue that she have been addressing. So this is a great debatable question that you have to develop writing an answer as such. So this example we talk about is in executive matters, as we have to read it with Article 74, fine. President acts as a nominal head. Now, in matters of president losing confidence and imposing or closing of the house due to no confidence motion, can she still act on the aid and advice of the Council of Ministers headed by Prime Minister? Which is answer is no, because who would cooperate in saying that that let us dissolve my own house. So that is not quite possible. There, the president can act independently, and she is not just a nominal head. Then, it's she is protecting or taking those orders under Article 60, which says about preserve, protect, and provide the constitutional provisions. So in those matters, the president is a constitutional head. Now, the conclusion that we should talk about is the president is a nominal head and the first citizen of India and the constitutional head also. And the president is elected through indirect elections, single transferable vote, and this voting percentage that have been made through, and all the elected people will participate in the elections of the president, and the it can broadly be divided into two categories. So the powers of president can be divided into two categories. One are normal powers, executive, judiciary, legislative function powers, and abnormal powers are like national emergency. So national emergency also we have read Article 352 and state emergency and the president's role, Article 356 and financial emergency Article 360, which has never been implemented till date. So these are all the important functions that of President of India. And one more important thing that you have to remember is the salaries and emoluments. So they are also charged upon the Consolidated Fund of India. But you have to understand the timeline of presidents of India, which is very important in the competitive exams that we have coming up. So I can discuss this, but let me finish. So, first president of India is Rajendra Prasad, and next is Radhakrishnan. Then there are two presidents that have died in office is Zakir Hussain and Fakhruddin Ali, and they have been two acting presidents, three acting presidents in dire of necessary. One was V.V. Giri, and the second one is Justice Hidayatullah, and the next one is B.D. Jatti. So these three people have been the acting presidents, and Hidayatullah has been discharged from the functions of the president. Oh, this is then Then there are these presidents have not cleared their terms fully, which could be seen in because Zakir Hussain died in office, he could not run through fully, and the acting president was V.V. Giri, and also Fakhruddin Ahmed also died in office after 3 years. So the acting president was then that time was Jatti. Then the Sanjeeva Reddy, Zail Singh, Sanjeeva Reddy, these two have had their powers during the emergency times. Then the other president who has finished the term is Venkatraman. Then Shankar Dayal Sharma, K.R. Narayan, Abdul Kalam, Pratibha Patil, Pranab Mukherjee, and Ramnath Kovind. And the current Draupadi Murmu, all these presidents have successfully finished their terms. So this is also very important from the competitive point of view. You have to know the president's office and etc. And the we have also read that now coming to diplomatic powers, this I said just said diplomatic powers, but diplomatic powers is the president can appoint the foreign ambassadors and other diplomats who represents India outside an international space, and president also has the authority to take necessary steps to have friendly relationships with the countries. And as we have read, she is the only authority who can declare war and who can declare promote peace and justice, and she appoints India's representatives to that of United Nations. So these are all the diplomatic powers of President of India. Now what we have read is, so these are all like basic necessary features that you have to remember, like executive powers, military, diplomatic, then legislative functions, then judiciary functions of president, and who can be uh, eligible to be president of India, and what are the necessary conditions, and how the elections are held to the office of president, and what are the terms and conditions, that has to be followed while being in the office of president. So the and this then what are the of functions of office of president, then who all can the president can appoint to the office, then what is the stake of president on various bills that should be passed in the house, and what are the powers of emergency powers of president while proclamation of national emergency 352, president rule 356, financial emergency 360, and what is the ordinance making power of president. This is also very important. Then the grant permission and pardon, reprieve, all those things. Here, president can pardon a death sentence, but if we look through the governor, governor cannot pardon a death sentence. So this is a difference that you have to remember. I'm saying it now because it will be useful when we are reading the governor chapter. Then uh, he also appoints the financial commissions. Then some of the constitutional bodies chiefs are appointed by president. So then we have spoke about the president rule and the issues. So the question will be like authoritative power of president, which may lead to president rule. So you can explain SR Bommai case. This is at 1989. So SR Bommai case dealing with Article 356, which is president rule. So these things also can be addressed in writing that answer. Then what happened in SR Bommai case? Like governor did not approve the Council of Ministers. Initially, he has accepted Council of Ministers letters to losing confidence, but later on he did not revoke once they again got back. So that is not how the constitution or the system works. Then emergency powers, critical remarks. This is the critical analysis of president's emergency powers. Like this are autocratic. This turns out that we sometimes totalitarian. You can give the example of president rule imposed in Punjab, Uttar Pradesh, and Kerala 8 to 9 times, and remaining other countries states 6 times. So more like which have disrupted not only the state machinery, but also it will also cut short the fundamental rights of the citizens and right against constitutional remedies, Article 32, all those things. And then the position of president, like you will also have to debate, is president the nominal head or the constitutional head? So you can say that in the executive functions, the under Article 60s and all, president acts as a nominal head because she has to act on the aid and advice of Council of Ministers headed by Prime Minister, which is Article 74. But if there is a loss of confidence or any disruption in the constitutional provisions, then their president can act as a constitutional head. She need not act on the aid and advice of Council of Ministers along with Prime Minister. So that debate you have to be able to develop. So then you can also conclude by saying, so one president is an highest authority, first individual and constitutional head, and summons the house, addresses the first session, puts more motion of thanks. So all these things you can also describe. So this is what the all the emergency and the powers that we have discussed today. So I hope you all understood. I hope you all understood today's lecture position, powers and functions of president, office of president. So if it's so, we can, yes, yeah. So please go through the lectures again and also read the material, and you please be aware of the articles and analytical answers. So, okay, yeah. So see you in next class. Yes, see you next class.